So welcome everyone to the consultation. It is Friday at noon. My name is Christina Jimenez.
My name is Karina Montoya.
Awesome. Alrighty. And today we are going to be talking about different complex legal issues. So Karina is a senior paralegal at our firm. She has been with us now for 12 years. And she is my right hand when it comes to the family cases. Anytime I have complex legal issues and I need to kind of talk through things with someone, she is my go-to person. And so thank you so much, Karina, for being here with us, or with me rather. And I think that we're going to be able to give some great info. So one of the things that I tell people all the time is do not accept this as legal advice. Okay, so we talk through these fact patterns that we receive, these random questions. But as we start talking through these things, you're going to see that we'll have this kind of conversation of, well, if this happens, then maybe the judge would do this, or if the other side did that, then maybe we would do something a little bit different, right? So when you're listening to this, kind of take little tidbits of information and then use that information to go and talk to your lawyer of your choosing to kind of walk through your particular issues, because one little nuance in your situation could change the trajectory of your entire case. Okay. Kiana always likes me to tell you guys to please follow us on all social media platforms. We have Facebook, TikTok, Instagram. We have, what else? Twitter, LinkedIn, all the social media platforms. If you guys could share, like, follow, all of that is really great, because our goal in doing this every Friday is to really kind of just share some information, hopefully help people become better parents, hopefully help them through this legal process, because it can be so difficult and so exhausting, and there's just not a whole lot of information out there. And so our hope is that we're kind of spreading a little bit of goodness throughout the world, and maybe that some of this might be of some use to someone. So if you know anybody that's going through something, make sure you share this, and hopefully they can glean some information from that. So with that being said, Karina, do you want to read the first question?
Sure. Yes, ma'am. So I am the non-custodial parent and pay child support every week. I obligated to split school supplies, backpacks, and new clothes with the other parent every year. My agreement says that we shall share extracurricular activities agreed upon, which may include the following: school activities and fees and bus fees. Does school supplies fall under the listed above? Shouldn't child support already cover these basic everyday needs? What do you think, ma'am?
So are you obligated to do it? No. Okay. So that's one of the things that I will talk to. Most of the time it's the mothers, right? Because a lot of the times the moms have primary conservatorship. But when they have things like school activity fees, they have, when the kids get older, cars, they got to pay for the car payment and the insurance payment and all that good stuff. There's always a lot of frustration, because the idea is, well, all of these things are very expensive, and sometimes child support isn't enough to cover it. And unfortunately, I would probably say that are you obligated to do it? No, you're not going to be obligated to do it. Judge isn't going to put you in jail if you don't do it. You, pursuant to this order, it says that you guys have to mutually agree upon stuff, right? And so if you guys are not mutually agreeing to stuff, which means if you say, I'm not going to pay for it, well, there's nothing else that she can really do about it. And so do you have to do it? No. Should you do it? Probably. Yeah.
I think you should contribute even if you're paying child support. I mean, especially because I don't know, I guess I look at it as, if I was paying child support, I would look at it like, even before, I guess, like before I was ordered to pay child support. I think we always, buy our children things that they don't necessarily need sometimes, right? And so I think, why just continue doing that just because you're ordered to pay child support?
Right. And I mean, so when Taylor, my stepdaughter, when she was itty bitty and she was living with her mom and my husband was paying lots of child support, we were still in a, I don't know, not even in a position, but it was kind of like a fun thing to do with her at the end of summer, right? Like, let's go back to school shopping, and she loved it and we loved it. And I just, it's one of the things, and I was talking to one of our clients about this yesterday, that there's always going to be kind of two perspectives of what is the legally correct thing to do, right? And what is just the right thing to do as a parent. And those two, unfortunately, don't always jive. Right? In this case, legally, no, you don't have to, but you probably should for the benefit of your kid. So now I would also say that if mom's, coming at him and saying like, you better do this now, or you have to do this, you get more bees with honey than with vinegar is the way that I always look at things. And so hopefully these two can come together for the benefit of the kiddo, and he should just pay for it, but you don't have to. So, all righty. So next question, when there's a preliminary hearing for an order of protection, so protective order, does the judge also have to look at previous charges you have? So my children's father is trying to get a protective order against me, and I was wondering if the judge would also look at previous criminal charges to make a decision on whether to grant it. Karina, what say you?
I think that yes. I think especially if the previous charges have to do with violence, domestic violence, assault charges, if this is not the first time, and there's just other charges that involve the same victim, I think it is, something the judge looks at, along with, the documents that are filed to request this protective order. Typically we always have to submit an affidavit, and explain the threat of violence. And so along with that, I think definitely he looks at the previous charges for sure.
So I guess let's talk a little bit about the difference between a protective order and a restraining order. And is my internet all sorts of jacked? Am I like in slow motion?
You're not slow motion, no. I do see it like it's a little blurry a little bit. Sometimes right now it's good, but it did get a little blurry. But it
was throwing me off a while ago, so sorry. So the difference between a protective order and a restraining order, and people always get confused about that. So temporary restraining order, how do you typically explain that to clients?
I typically compare it to the standing order, from the Dallas and Denton area, because, we do those cases as well. And so I just basically say that it's, it maintains the status quo, I guess, just kind of keeps everything the same so that, people don't try to start selling things, start harassing each other, start changing locks, on the homes, or taking over vehicles or things like that. And it just puts in place that order to,
so you're
protect the rights.
You're nicer than I am.
What do you say?
So basically this just means don't be an asshole.
Yeah.
As long as you're not doing things that you normally wouldn't do, you're gonna be cool, right?
Right.
But it's, there's orders that say don't harass, don't disparage, don't run up credit cards, don't cancel insurance policies, don't change your retirement distributions or deposits, whatever you call it. There's a list, and a lot of times it's like 30 to 50 things that you cannot or should not, you cannot do it, because if you do it when you're served with that restraining order, then you could potentially be held in contempt of court, right, for violating. And so everybody, not everybody, but a lot of people, they're going to freak out when they get served with a restraining order. And I will tell you, in all family cases, divorces, child custody modifications, even sometimes child support cases, like we serve restraining orders, because what we don't want to happen is that somebody gets the paperwork and all of a sudden they freak out and they go and withdraw the kid from school and they hide the kid, or they just do something stupid, right? So it is important that if ever you're served with a petition and you also happen to be served with a restraining order, that you go to an attorney and you read the restraining order. Because I can't tell you the number of times that I've had to do a consultation and they come in and they say, well, I haven't seen my kid in 2 weeks or 3 weeks because I was served with this restraining order. And so I didn't think that I could talk to them. And it's like, it's not what this says. It says that you can't threaten mom, right? You can't disparage her, but you can see your kid. So read the restraining order. Some restraining orders are going to have what we call extraordinary relief. And so, Karina, you want to kind of talk on that?
Yes, ma'am. So as far as extraordinary relief, when it pertains to kids, you know, there's situations that are, you know, cause the children to be in danger, whether it's drug use, violence, you know, child abuse. There's just so many different situations. But when the children are being put in, you know, immediate danger, we can file for extraordinary relief. We draft affidavits, we explain to the judge the situation, what's going on with the children and what's you know, what they're facing, and we file the documents, and then we can ask the court to grant extraordinary relief, when or if they do, then that parent that is awarded the extraordinary relief does not have to release the children to the other party until we go to court, and then the judge determines, you know, what happens with possession, visitation, all that stuff.
And so typically what will happen, at least at our firm, is the clients will have what we call an initial paralegal meeting, right? And so during that meeting, the paralegal's kind of getting all of the information, making sure that all of our client preliminary documents that they need to fill out, that all of that stuff's being processed, and then they're talking to them about the facts. And then typically what will happen is if something kind of crazy comes up, I'm going to get a call, or Floyd or Julie or James, somebody's going to get a call and they're going to say, hey, this is kind of a crazy situation that's happening. Do you think that this is an extraordinary relief situation? And then we kind of talk through it and we say, yes, this is, or it isn't, or maybe it could be. And we kind of strategize from there. When you do an extraordinary relief affidavit, what you have to show is that the child's present circumstances would significantly impair the child, and it's a immediate and irreparable harm is the standard, right? And so a lot of times if I have a situation where maybe something happened a couple of years ago or 6 months ago and there's nothing recent that has taken place, a lot of times we may not want to file that, or we may file it to kind of make the client feel better about the situation, but we obviously tell them, like, listen, this may not be granted, right? But if you get into a situation where there's drug use, there's family violence, there's something crazy, like those are no-brainers. We file them, and then typically the judges will sign them pretty quickly. So when that happens and you get, that's why I say read your restraining order, because some of these restraining orders that the judges sign, and I guess let me back up a little bit. So what happens is we do the affidavit, right? And we say, based on this person's knowledge, this is what we know. We take that affidavit along with our motion to the judge. We present it to the judge. Judge reads the affidavit, and after the judge reads the affidavit, if the judge says, yeah, these kiddos are in danger, then he signs the temporary restraining order with the extraordinary relief. And at that point, you are denied access to your kiddo. They can send a sheriff to the other parent's house to remove the kiddo via writ of attachment. And then obviously that child will stay with the other parent until such time as you go to court, like Karina said. Okay. So what happens if you violate a temporary restraining order? What has to happen is the other side files a motion for enforcement for you violating the TRO. You're entitled to notice. You're entitled to be represented by counsel. If you can't afford one, they will appoint one for you. And then the judge makes a decision on whether or not you violated the restraining order and whether or not you should go to jail. Okay. If you're looking at a protective order, the purpose of it and the violation of it is completely different, which is what this question was about. And I went like everywhere
to explain. Yeah.
I'll get a lot of crap right now. But going back to the protective order. So when we're looking at a protective order, what we have to show is a history or pattern of family violence, and then also a threat of future family violence, right? And so, like you said, Karina, all the criminal history, all that crap, I think it all comes in. And based on this question, I'm going to go ahead and say that mom, this is mom, right? Or is it dad? Yeah, mom, because the children's father is trying to get the protective order. So I'm going to go ahead and say that mom probably has an extensive criminal history.
Yeah, if she's worried about it, definitely. Right. Are you there? You froze a little.
Yeah, I'm here. So mom, if she has an extensive criminal history, judge can take all of that into consideration. And depending on what those offenses showed, then I think that you can use the past criminal offenses to kind of prove or establish the threat of the future offenses, right? Or the future family violence. And so, yeah, sorry, mom, that's probably not going to go over well. Now, Karina, what happens if you violate a protective order?
Typically, if you violate a protective order, all these provisions are in the protective order, like that you can't be around the victim, the applicant, you can't be, sometimes within 350 feet or within a mile, or, at their place of residence, their place of employment, the children's school, if the children are included in the protective order. And typically, initially they are, and then sometimes they're removed in the future. But if someone violates the protective order, all the applicant has to do is contact the police, law enforcement, and they get arrested. It's not like a temporary restraining order. They will get arrested because it's that, I guess the gravity of the situation is usually, the violence and the threats, and it's scary.
Yeah. So, I mean, when you're looking at a restraining order, and the restraining order in a civil case that's normally imposed, they're standard, right? And even if it's an extraordinary relief situation, it's not where we have, or the court has, this legitimate fear that if they don't grant a protective order, that something really bad is going to happen to someone, right? And so I think that's kind of the context or the thought process behind this is why you need to do the protective order, this is why you have to be arrested if you violate the protective order. And I think the first violation is a Class A, and I think the second violation is a state jail. And I think that if you violate a protective order, if you had previously violated a protective order, then they can, the final protective order will be granted for 2 years. And so, and you also can't carry a handgun if a protective order is granted against you. And so you don't want to mess with it is kind of the point of all of that. So, and the other thing is, so I will tell you, like, I have had clients that either a protective order was granted to them or against them before I got involved or even afterward. And, sometimes the exes are crazy and they're making stuff up, right? But they come off very credible. And the judges, when we go into the court and we present evidence, they believe the applicant, right? And so when I have those situations, I will a lot of times tell my clients, you need to have a tracking device on your vehicle, because if they're going to come in and make a false allegation that you violated that protective order, I don't want you to end up in prison because she's saying that you drove by our house, right? We have to come up with different creative ways to try to be protective of our client. And sometimes you can't do it, right? Like, we're not going to know where our clients are all the time, or how are they going to prove where they are all of the time. But we try to get creative with that because we've had some baby mama drama in the past.
Or,
Yeah.
a lot of times the applicants are the ones that reach out, and it's that cycle of abuse. They're the ones that reach out and they're like, hey, come over, hey, and they're calling, and sometimes they think it's okay because the applicant is the one that's reaching out. And so they initiate contact, or, and so there's, well, she's the one that called me, or he's the one that called me, and it's like, it doesn't matter if there's a protective order against you, you cannot violate it. It's just not in your best interest. So.
Right. Well, and I mean, if I had a nickel for every time that happened, right? Like the ex comes over or calls and says, come over, and then the clients go, and then there's an argument and the client's there and the police show up and now they're picked up for, violation of a protective order. So yeah, and the other thing that I will say is, and I've had this happen too, where people have this, I don't know how to explain it, like sometimes, and it's most of the time it's women that will move for protective orders, but the woman will file for the protective order, and sometimes it's truthful, right? And sometimes like the husband has done really bad things with a boyfriend or whatever, and sometimes it's maybe not that bad what had happened, but the wives or the girlfriends, the women still want to move forward with it, right? And then they get the protective order, and then 2 or 3 months passes, and then they regret having filed for the protective order because they have kids or they want to get back together or whatever. So I have had it happen on a couple of different occasions where the mom decides, or the woman decides, I don't want my 2-year protective order to be in place anymore. When that happens, you have to go back to the judge and you have to request permission to vacate that protective order. And I have had it on a couple of occasions where the judge says, too bad, so sad, not doing it. You came in, you said that you were a victim of family violence and you were scared for your safety, and not going to vacate it. And you talk about putting people in a really hard situation. So you got to look at it on both sides, right? If you are the move-in, make sure that it's really something that you need in order to keep yourself safe. If you're the respondent or the person that's having the protective order granted against you, make sure that you have a good attorney. You understand every little thing you're supposed to be doing, because we don't want you to end up in jail. So cool. Anything else on protective orders? That was a lot.
Yeah, that is. I mean, I think I was just thinking about, typically they get arrested initially with the assault, and then when they are bonded out, they think they can go right back to the place where it happened, typically their residence, and they can't. Also because of the EPO, emergency protective order, that's in place sometimes for 30 days, sometimes for 60. And so they think, oh, I just gotta pick up this, or I'm just gonna go, and it's like, no, you can't. I mean, you have to wait it out. So
do you remember we had a case where it wasn't an EPO situation, but we went to court, the judge granted the protective order, we represented the wife, and the protective order was granted against the husband, and judge signs the protective order like right then and there, and the husband's pissed, and so he takes off and doesn't talk to his attorney and leaves the courthouse, goes straight, like literally straight back to the house to pick up his clothes and to do whatever. And within like, I don't know, 10-15 minutes, the sheriffs had picked him up, he was arrested, and I was just like, come on, dude.
yes, exactly. It's unfortunate because I mean, I just think sometimes people just either they don't know, or sometimes they just don't care and they ignore it. But with these situations, You can't. I mean, it's a big deal.
Well, and I'll say also, like in our office, and I think that it's good sound advice for other attorneys to do this as well, is to review your orders with your clients, right? And so when we first started out, goodness, Karina, you've been with me for like almost as long as I've been practicing.
Yes.
That's
Hello.
crazy. So when we first started out, like you and I,
It wasn't like that.
yeah,
We
we
were
didn't.
learning as we were going.
Exactly. We like literally grew up together in this field. Like we were just
Yeah.
kind of figuring it out.
Yeah,
So
we were like, oh yeah, we're reading your order now. And you can't do that. You can't, or they'd show up, yeah, like with the applicant. And I'm like, you cannot do this. You gotta go. What are you doing? Yes.
but yeah, so when we started many moons ago, we didn't go over orders with our clients because it was not common practice. It was time consuming. We just assumed that people would read their orders because it's a court order and they would know and understand. And so I'd say probably like 10 years ago or so, maybe a little, yeah, about 10 years, we started doing what we call order review meetings, where we will literally, one of the attorneys will go over the order with the client. And I still know to this day that there are a ton of attorneys that don't do that with their clients. And I can't tell you the number of times that people have been completely screwed over because they just didn't understand something. And so when I go over an order, I don't read it to them verbatim. I'll just say, okay, here's what this clause says, right? But in layman's terms, don't cancel the health insurance of the child, or make sure you're sending these payments into San Antonio, and if you don't, you're not going to get credit. So that way they know this is what's expected of me, right? And so I'd say 9 times out of 10, we're doing that with clients. Sometimes we can't get a hold of them, or there's issues, or, they don't want to go over it with us or something. But most of the time we do go over it with our clients. But you got to make sure that you understand it. And lawyers, we should really make sure that our clients understand it too. So, especially if it's a protective order. So with that, I don't think there's anything else on restraining orders. I think we're good. You want to read the next question?
Yes, ma'am.
Okay.
How can I legally force my dad to hand over my social security and birth certificate, etc.?
That's the one I said, I don't know. I have no idea how to answer this question. So, do you know how to answer the question?
No, because I think there was an issue in there that I was like, I don't know about that one. So we're just gonna opt out of that question.
Moving on.
Let's just move on.
Next question.
If I'm filing for full custody with visitation rights, should I still tell the judge about my move out of the state? So I'm the custodial parent. I am trying to file for sole custody with visitation so that my child and her father can still see each other. A temporary order was already established, which allowed him visitation, but he is an uninvolved parent. Also, I'm trying to move us out of the state and wondering if I should tell the judge about the move.
So it depends. It depends on what the order says, right? So if the previous order, the temporary order, does not have a geographic restriction, maybe they don't have to tell the judge, because we're not modifying the geo, right? I don't know. We're not doing anything. We're just trying to change, I guess. Well, she wants sole custody and with dad having visitation. Honestly, the best policy?
Yeah, I mean, I definitely think yes, especially like at a final, but I think if you don't have a geographical restriction and this person is not involved, I mean, so long as you notify all the entities, you know, the child support agency, the state disbursement unit, the other party, and then you follow the order that way. I think also you could move and then, or what do you think? Because I
I
mean,
mean,
like you said, we're not modifying.
yeah, and I mean, honesty is always, I think, the best policy whenever you're dealing with a court hearing. So when you're dealing with a judge, and I always try to look at things from the perspective of, if I were going to have to answer to the judge in, you know, a month or 2 or 3, like what, and he found out that we went to a temporary order and then we just bounced without telling him, like that probably would not go over very well. But I think it just depends on the case. And I think that if dad is not involved anyway, I don't know that judge would really have a problem with you moving, right? I mean,
So what do you think we would do in that situation though? Like schedule a hearing, just like a status hearing, and try to notify the respondent, or
what I would say is that if there was not a geographic restriction, if the temporary order did not have a geographic restriction, then I would probably just tell the client, you can go. Like the order already gives you the right to do so, so you can move. No big deal. And then once you move, we can then see how dad does with his visitation. And if dad is exercising his visitation and you don't like it, or you don't want him to have that, then at that point, after you've relocated, we go back in and we modify just the visits, right? Obviously, if there is a geographic restriction, then she cannot move until we go in to modify the temporary order, requesting that it be lifted and requesting that dad's visits be changed. So I think that's probably how we would play that. So, and I think even if she had the geo, if we could establish that dad is not exercising visits, he's not, you know, paying child support, he's not going to extracurriculars, he's not doing all that stuff, judge is going to let him or let her go 9 times out of 10, right? So I guess, should we talk a little bit about geographic restrictions and why we have them and why a lot of people hate them?
Yeah, I mean, I think it's just like typically when people separate, you know, a lot of times they want to just, I guess, establish a new life, just kind of move somewhere where, you know, there's not all this drama, especially when it's high conflict. But you know, they're there to ensure that the children are, you know, close to both parents. And I think I mean, it's important, even though they don't get along or whatever. It is important for both parents to be close to the children. You know, in some instances it's not possible, and people try to make the best of it, but I mean, yeah.
So I'll say, like, that is one of the things that I see so often in AG orders, right? So a lot of times people don't hire a private attorney, they go straight through the Office of the Attorney General, and the Office of the Attorney General will either do an administrative review hearing, or they will just schedule like a temporary hearing or a final hearing. And a lot of times what will happen is you kind of get pulled back to the back with either an attorney or somebody who works for the AG, and they go through and they fill out this 30-page document that ends up being your court order. And I would say 9 times out of 10, they do not check the box where the custodial parent has a geographic restriction. Which means if they don't check that little box, the mom, whoever has custody, can move anywhere they want to in the world, and there will be nothing that you can do about it. And so you need to make sure that if you're going in and you're not represented and you're having, you know, any sort of child custody issues come up, that you have your geo checked if it's important for you to stay, or if it's important for your kids to stay near you. Otherwise, you're setting yourself up for failure. I will also say that 9 times out of 10, judges are going to impose it, and it sucks for a lot of people. I'll say like the biggest hardships that I see that it works is like if somebody gets remarried and their spouse lives out of state or out of county, and maybe they have, a kid and they need to move and they can't because they have the GO. I have seen tons of people lose custody because they just decided that they were going to disregard the GO and they were going to move without the court's permission. Don't do that, because the judge will give the other parent custody. And I have seen judges quite often deny a request to move. I had a client several years back where her husband got a job someplace up north, and he was going to be making something like $400,000 a year, like really, really good money. And so she wanted to obviously move up north with her husband. And they had agreed that they would fly the kiddo in every single first, third, and fifth weekend on their dime. That all Christmases, summers, etc., they would allow the kiddo, or they would fly the kiddo to dad. I think that we had offered like no child support. It was like really, really sweet offer. And they wouldn't accept it. And then we ended up having a contested hearing, and this judge said, sorry, but you can go, wife, but your kiddo can. And yeah, that ended up, I don't think she ended up moving after that, but it's tough. And we've had some too, like military situations where the husband gets stationed in another. Yeah,
that's unfortunate, but it's part of, you have children or a child with somebody, and that relationship is important, and people move on, but both parents being in close to the children, and people do whatever they can to make that relationship work when they move. But I definitely think that especially if they're good parents and they want to be involved, and of course there's some parents that are not involved, but in that case I think it is really important to keep them close by, when they're trying, when they're not just trying, I mean just when they want to be involved. That's important.
Right. Yeah. And I mean, and that's like you said, Karina, that's the biggest issue is the other parent active? And like in this case, if dad's uninvolved and he's not doing what he needs to do, judges will say, okay, you're not exercising your visits. But if dad's coaching, and I think in that case, dad was like the coach of the baseball team, and once a week he was having lunch and all the parent teacher conferences and all the doctor's appointments, like he was a really good dad, a really active dad. And I think that's what judge was like, nope, because all that stuff would be taken away from him. So anyway, okay. So yes, tell the judge. Hopefully everything works out. Number 5, can me and my baby's father get married while he's in jail? And I have a restraining order against him. So he was charged with a domestic violence a couple months ago. He was kicked out, and now he's back in jail for another reason. But we want to get married while he's still in there. Is that possible?
I believe so. I believe there's a way you can get married, while the other party is in jail, by proxy. I mean, and I'm a little confused, I guess, by their question. I'm not sure if they're asking about this restraining order. I guess it's a protective order and they're just calling it a restraining order. So back to what we talked about earlier. But if it's a protective order, I mean, they shouldn't be visiting.
No conjugal visits for you, sir.
How would that work, actually? I mean, if she's the one visiting and there's a protective order.
I don't think that she can. I think that they could be married by a proxy, because I don't think they obviously are together when that happens. It's just basically like paperwork. And so I think that could happen, but until such time as that protective order expires, which, I mean, she said a couple of months ago, most emergency protective orders expire, I think, on the 61st day. So their EPO is probably about to expire, which means that, yes, he will have his conjugal visits.
Makes
So
sense.
it'll be okay. But I mean, I guess why? That's a whole other like mental health and family violence issue.
Right. But I'm sure the, like prisons and the jails, they have rules against, victims and things of that nature. So I mean, as long as I guess they meet all the criteria to answer their question, I'm sure it's possible. But
Yeah. Easy breezy. Next question.
Number 6, right?
Yes, ma'am.
Okay. I started a new job but was hesitant about adding the workplace to the restraining order because then the defendant will have another place to look for me. Must I update my restraining order right away? Am I able to seek child support through amending the restraining order to avoid court altogether?
So you can tell that these people don't have attorneys when they ask them these questions.
Right.
So I would probably say don't put in the time and the energy to amend the workplace, like, because generally it says in the TROs, it doesn't say that they can't go. This is another protective order issue.
Right. I think people definitely confuse, and maybe in other states they're called restraining orders, but at least in Texas, they're typically called protective orders.
And so when we draft our applications for protective order, typically we will include the place of employment, the address, and then we will also include the physical address of where you're living. But we always have this catch-all provision that says do not go any place where this person could be found, right? And so I don't know that it's absolutely necessary to add in the place of employment. I guess if you don't do that, then the potential defendant could say, well, I didn't know that she worked there, right? It kind of gives them a little bit of deniability. So I guess safe practices always include it, but I also understand her concern about him now knowing where she works and following her and harassing her and doing all that stuff. So I say don't amend it. What do you think?
I think even when we talk to our defendants, and we say it doesn't matter if it's not included in there, right? Because let's say they walk into a nail salon with their, I don't know, they have a new partner, or they go right to the nail salon, and the other party's there, or the applicant is there, then they have to leave. I mean, they're not allowed to be within a certain distance from the applicant, and so I think it covers them. So yeah, I mean, I don't think I would waste time and energy and money in amending because I think they're protected.
So my son's like banging something in the kitchen. I don't know if you can hear that, but if so, my apologies. Yes, 17 more minutes and then he will be. So yeah, I say save your time and money. Now, asking for child support through amending I'm going to say protective order. I think they're talking about a protective order. And so you actually can ask for child support and like custody, conservatorship, visitation, parenting classes, all of that. You can ask for that in an application for a protective order. You don't commonly see that. Like typically what will happen is you'll have a SAPSER or a petition for divorce, and then you'll have a separate application for protective order. But you can, and but you're not going to get it right away, right? You're going to have to go, you're going to have a hearing. The judge is going to hear the evidence on the protective order and also on all the conservatorship stuff, and then make a decision on what should happen with that. So, okay. Number 7. My turn to read or yours?
It's your turn.
Okay. So how can I divorce my husband who won't agree to the divorce? I had a protective order. What's up with all the protective orders? But his sister talked me into letting him back in the house. So I canceled the order. So dumb of me, as he is sober now, but is still the terribly verbally and emotionally abusive person. My adults and older children could even testify to that, as he has done it to them. I feel trapped and want out so badly. I don't know what to do.
So how can I divorce my husband who won't agree to divorce? So if there was a previous protective order granted, and even though he's sober now, I think, we file for a divorce, we get him served. A lot of times, that in itself is a scary situation, is getting them served, because a lot of times these people that are abusive don't think that the victims will ever do it, that they, will get the courage to actually follow through. And so sometimes we might file another protective order with the divorce, and or even extraordinary relief. I don't know if they have children together. I know they have adult children, but could we do extraordinary relief to maybe try to like a kick out order?
You can't do
No.
that if there's young children and
Then
you get an order denying dad, access, then the implication is he can't be in the home, right? But no, the only way to kick somebody out of their house is if you get a protective order, period. And so, and this whole thing that she filed for the protective order and then she dropped the protective order. And now he's here recently, he hasn't really been doing anything. He's just verbally abusive. She may not get it this time. Yeah. And so, you mentioned we would file a petition for divorce and then we would schedule a temporary hearing. And I will tell you that sometimes these temporary hearings take a month, 2 months, depending on the jurisdiction to get in. And in the meantime, you are living with this person because you can't kick them out because you don't have a protective order. And it sucks and it's hard and it's draining and it's scary. But there's nothing that anyone can do until you have a contested hearing, period.
Do you think they should leave?
It depends on the situation. So what I tell my clients is if you are scared for your physical safety and your mental health, then yes, you need to leave. Now, the potential ultimate consequence is that when you go to that temporary hearing, the judge will likely maintain the status quo. And so if you have moved out of the house and you're living with one of your adult children and you are working and kind of taking care of business that way, and the husband's been in the house and he's been paying the mortgage and paying the bills and he's taking care of his business that way, it is very difficult to show up to a temporary hearing 6 to 8 weeks later to say, hey, JK judge, now we want back in the house and he needs to go and find someplace else to live. Lots of times judges won't do that. And so, and I've been on both sides of that argument. And so it's it could be that's the potential consequence. And I will say that 9 times out of 10, my clients that are really, really scared about their safety and welfare, it's like not even an issue. It's like, I'm leaving. Like, I don't care if I lose the house, I'm going. And that's that. But some are like, no, I can't do that. I have no way of supporting myself. I have no place to go. And then they're just stuck. So, and obviously in those cases, like, we monitor those clients very closely. We're in constant contact with, if anything crazy happens, if the police are called or anything like that, then boom, we go in and we file the protective order at that point. So, and that's even more difficult when you have young kiddos, because then they're stuck. And so in that particular case, I would document every single thing that's happening, right? If they're yelling and screaming and throwing and doing stuff like that, try to get documentation of that, get recordings, get whatever you can, witnesses, call the police if something like that happens, so that we have something to support the argument that they should be the one to move and not you. Right? So what else? I think that's it on that question. And so I think one more question, which one should we do?
The number 10.
Number 10. So is it considered kidnapping if the mother, is it my turn to read or yours?
It is my turn.
Okay, go.
Is it considered kidnapping if the mother moves the child out of the state and never told their father or obtained permission from the court? The mother got my son arrested and put in jail, but he's always been a great father and very much in his son's life. After the arrest, the mother took the child and moved to another state without telling anyone. We went to court and were awarded emergency custody. She has never shown up to our court date or the one for her charges on my son. Can she be charged with kidnapping?
Negative, ghostwriter. So she can be charged with interference with child custody, which is also a felony. But not, I don't believe kidnapping. I don't think that would be a thing. I don't think that the police would pursue that. And honestly, even on these interference charges, it's like the police file the ones that they shouldn't file, and then they don't file the ones that they should file. And so basically what interference with child custody is if you have a court order and you don't comply with the terms of the order, right? So there's two potential consequences. The first is the other side could file a civil action against you for a motion for enforcement to put you in jail for 6 months, okay? The second is that the police could arrest you for interference with child custody, okay? And so it's kind of interesting. I don't know. I wish James and Julie were here. Because if she's out of state, I guess they could file that and then they could issue a warrant, and then that could potentially be a way to recover the kiddo too. But a lot of officers won't do it. Yeah. A lot of times, what do they tell us, Karina?
It's a civil matter. It's a civil matter. I wonder though if the respondent was served, right? Did the mother get served? And I guess they were awarded emergency custody. She's never showed up to the court dates or for the charges against the son. So, I mean, it sounds like they already defaulted her potentially. And so there's ways to get the child back. But I mean, as far as the kidnapping is concerned, I don't think that would hold any water. But yeah, get the child
Tell
back.
me how we get the kiddo back.
Well, I think they could file for a writ and then go to the other state, and I mean, and I don't know. I know we've had some states that don't honor the writs, and we've had to have our clients actually go to the other state and file there. There are some states that, they have honored them, and then, they're able to recuperate the child that way. But yeah, we just filed, and we explained to the court that this person, the petitioner, is supposed to have the child in their possession, and that the other party has them without permission, and then move forward that way. But yeah, I guess it just depends on what state they're in.
Yeah, so basically the way that it works is if they have, she says emergency custody, what I'm going to go ahead and say is that it was like a temporary order, right? Where it says dad has primary conservatorship. Okay. And so once they have that order, if mom doesn't release the child the way that she's supposed to in compliance with the order, then at that particular point, you can file what we call a writ of habeas, which basically says I'm entitled to current possession of this child and she's not giving me the kid the way that she's supposed to. And or you can file a writ of attachment asking that the judge that the judge order sheriffs or constables to go in and pick up the child and physically, can you hear my son?
Yeah.
This kid. School's almost starting and it's gonna be but they will order a sheriff or a constable to go and pick up the kiddo and deliver that kiddo either to the court or to the other side. And like you said, so the writs typically say that it orders any peace officer within the state of Texas. Okay. But we have had some sheriff's deputies in other states that will still, I guess, just do it or honor it, or they'll just help. They just want to help. I would say other times, and most times, what will happen is we're going to have to take the order that we presently have with the writs. We're going to have to register that order in another state, and then we have to get local counsel. Give me a second. I'm sorry. We're almost done. Then they order, the new attorney in that state will get a new order to say, hey, sheriff deputy in Florida, go pick up the kiddo and deliver the kiddo to dad. Dad is then going to have to drive all the way to Florida to pick up the kiddo. And that's always kind of a logistical nightmare to work all that stuff out, but we've done it before. And I think that's kind of should be the main concern, right? And the main issue is getting the child back. And then the other thing that you could potentially do is, instead of filing the kidnapping charges, you can file a motion for enforcement so that you can hold her in contempt. And most often, like what I do in these types of situations is I will have my client text, email, send messages to family saying, here's this order. She needs to give this kiddo back to me. Because a lot of times we don't know where they are. Like we can't even find them. So we do everything that we can to put mom on notice that there is an active order in place. And then we use that when we go into court to say, look, judge, this is why you should put her in jail, because she knew and she didn't give the kid back the way she was supposed to.
Yeah. And at that point, they set themselves up for not being able to see their children. And there's just so many consequences to that, because, then the judge, or you can't trust that they're going to bring them back, or, there's just like a lot.
Yeah.
So, yeah.
And we've had cases like that. One in particular where the mom was very fearful that something really bad was happening to the kiddo, that there was, sexual abuse going on in the other household. And we had gone to court. We exercised our best efforts to prove that these things were going on, but based on the age of the child and the limited evidence, like it was just couldn't prove it. And then mom decided that she was going to take off with the kiddo. We couldn't find her. Dad couldn't find her. The FBI, or not FBI, state troopers, I think it was. I don't remember. But
Ranger or somebody. Yes, ma'am.
Yes, they were looking for her. And when they finally found her, obviously dad was able to get custody of the kiddo. And she had a long road ahead of her with supervised visitation and proving to the judge that she could be trusted. And so I know that it's scary. And I know that the legal system is not always perfect. There's going to be things that happen that probably shouldn't. But don't abscond with the kid, because I can assure you 9 times out of 10, we're going to have problems. So.
Yeah. And it takes a while, but, I think sometimes it's better, to do things the right way.
Absolutely.
Not sometimes, it's always better to do things the right way.
Yep, absolutely. So thank you. Oh, look, Julie told us the kidnapping. If it's their own child, it's not likely that they will file kidnapping. It's possible, but highly unlikely. Interfering is the more likely charge, assuming there is a custody place in order.
Thank you, Julie.
Julie, come back. So let me find our lovely little disclaimer. So we say this at the beginning, middle, and end of all of our Facebook Live events that you all should not accept this as legal advice, because every little nuance in your particular case can change the entire outcome of what's going to happen. So please, 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 if you find yourself, and I'm trying to pull it up, but my computer's not cooperating. If you find yourself in this particular situation, reach out to a good attorney, preferably somebody who handles cases in your particular jurisdiction, and listen to their advice and follow their advice, because they are going to be able to provide you with the best possible information and legal counsel. So with that being said, Karina, thank you so much for spending Friday with me, and I will talk to you soon.
Alrighty, bye.
Bye.